Hello, my name is Kevin Nugent. I'm Vice President with Discovia. I'm speaking today about trade secret investigations and current trends in the area of trade secrets investigations. The key to, I think, any topic related to trade secrets has really got to go back to the 1996 Economic Espionage Act, where for the first time, trade secrets were truly defined. There's really three components that identify whether or not information is actually a trade secret. The first is it actually does have to be information. And that information can be in the form of formulas, it can be in the form of contacts, it can also be in the form of spreadsheets. So there's various different ways that information can be categorized. The second is there have to be measures that have been taken to significantly protect that information from being taken. And then the third area is really focusing on the fact that that information, that there's actually a personal gain or a monetary gain for that information not being divulged or not being known. If it meets those three criteria, you've now defined truly a trade secret. So now the problem to deal with it is understanding, has a trade secret actually been taken? If you have identified that a trade secret's been taken, you've really got three primary recourses. The first is to really utilize the resources you have internally. In most cases, that's in the form of an employee agreement. Typically, when employees come on board with companies, there are specific restrictions preventing them from taking information with them, also too from pursuing, soliciting employees and so forth as part of those employment agreements. But the key here is on protecting the assets or the corporate collateral of your company. So as long as those are embodied in your employee agreement, you have that as an immediate recourse. So if an individual has left the company, you have strong belief that they've taken trade secrets with them, you can utilize your in-house counsel to then approach the individual, falling back on the employee agreement which they signed, to ask and compel them to return the information which was taken. If that recourse doesn't work, you really have one of two avenues to take at that point. The next is to take it through civil action. Now there's pros and cons with both civil and a criminal approach. With the civil action, there's going to be a considerable amount of cost involved. The key to this is, if you're taking this through a civil action, in order to get a temporary restraining order to identify the fact that the individual has used that trade secret for personal gain, you have to have enough information and enough probability that the individual, number one, has taken the information, but also two, that you strongly believe and have evidence that they're actually using that information for either their personal gain or the personal gain of the company for which they're now working for. So there's costs involved from a forensic analyst perspective, getting them engaged in conducting the investigation, and then actually going through the litigation and moving the litigation forward at that point. These can sometimes be time consuming. The other downside to this is a publicly traded company. You've now put yourself and your company out on the forefront in the public domain. So anything that takes place with regards to the matter now becomes front page news. So provided the publicity is not an issue, this is not a bad way to go. And also too, if you have the resources, financial resources, to be able to sustain and run a litigation going this route. The other avenue is to go with a criminal investigation. It's a little bit harder to go in this direction because you need to be able to compel the federal government to get engaged and want to take the case on. Typically, the federal government is looking for a couple of key criteria to take place in order for them to want to take a particular case on. Those criteria are really if there's a foreign national involved, if there's a foreign entity involved, a foreign company who's going to benefit from that trade secret being stolen. Also, too, the federal government is looking for large sums of money that will be involved in that trade secret, should the trade secret, of course, be used by that foreign entity. In those cases, the federal government, in most cases now, is compelled to jump into those matters and take those matters over. Now, the difficulty with that is you've now lost control of the matter, and you've got the federal government with the DOJ who's really driving that particular matter now and driving the case, the investigation, and so forth. Now, going the criminal route is also going to take a considerable amount of time to go through that process. So again, you've got to weigh the pros and cons. The pro to that being is if you don't have the financial resources to take this through a court action, then the criminal route is a good way to go. There's no additional cost to you as your corporation. The federal government is now pursuing it. And more importantly, if there's truly an emotional anger with regards to the individual taking the trade secret and using it for personal gain, the criminal route is a good way to go, because what happens on the back end of that, should the individual be found guilty, is there is jail time involved in it, there is prison, there is sanctions, and more importantly, in those cases, the company they've gone to work for gets involved in the matter as well. So the criminal route is not a bad way to go either. Civil route, as long as you have the resources and you have the time, also is a good route to go as well. Now, the other factor to really weigh into this is to determine what's the best case to prevent a trade secret from being taken. Well, there's a couple of them. And again, first and foremost, goes back to the employee agreement. If you've got strict covenants within the employee agreement that prevent the employee from taking trade secrets, that's number one, a stopgate. I equate that almost to if you have a security system for your home, you have to put a sign in your front yard that basically says my home's protected by ADT or it's protected by Guardian. What you're doing is really putting up a warning to individuals who are going to approach the house and thinking about stealing something from the house. They know it's protected, they know there's risks involved associated with proceeding further. That's really what you're doing with an employee agreement. You're laying out the confines to strictly regulate what they can and cannot do with the equipment. There's some companies who've actually taken this a step further and actually restrict specific access with company-issued desktops, company-issued laptops as to what they can plug into those devices. In some cases, those devices are company-issued hard drives or external drives, and that's all that can be accessed on the computer. If there are breaches on that, which are detected through regular audits of the equipment, that's determined as a breach of that employee agreement. So you can begin to manage and regulate, again, being proactive to prevent an individual from wanting to take information out or giving them access to take that information out. There are also now some companies who have gone a step further with regards to incoming employees, indicating to them that if they do in fact bring trade secrets from a former employer and utilize those trade secrets, if there's litigation that's brought against them, that they will not be held liable for any litigation associated with the matter, and more importantly, if the company is implicated in that particular matter, the individual now has to assume responsibility for the company's litigation costs. So it's a huge liability for an individual coming into a new company to take that risk and bring the information into the company. So those are a couple of the key risks. What you can do to prevent is, again, do preliminary audits, have regular audits on a quarterly basis or 6-month basis, depending on what's convenient for the organization, to determine whether or not information has been taken. The key is, how does the information leave the organization? A number of different ways, and it's becoming more and more complicated now, especially with cloud. So a couple of the key ways: number one, email, which is relatively easy to track. You also have access through phones, through cell phones, smartphones, cameras. You also now have external hard drives as well, which is exactly how William Snowden took the information he took, was actually via a thumb drive. So there's a lot of different ways that the information can leave. The difficulty is in trying to lock that information down as much as you possibly can. So the key is really focusing in on preventing the information from leaving the organization to begin with. But once it does, identifying what's the best course of action for your corporation to take, whether it's using your internal means first, which is the number one approach, and then secondly, whether or not you want to pursue the matter through civil litigation or if you want to pursue that through criminal investigation.